Hello, my name is Michael Tesoro, and as you can see, this is ACCC cheat sheet for December 2024. So I'm getting close to having caught up. As you can see, it's 31st of January 2025, and it was a big month, December. It took me quite a while to do this particular cheat sheet. There's quite a lot happened in December. Bit of background about myself. I'm a competition and consumer lawyer, and I've been running my own practice to sale legal consulting for about 18 years now. I help companies, individuals with competition and consumer law matters. I also do a lot of consulting work for various legal publishers about competition and consumer law, and I also sit in the commercial division of NCAT and get my hands dirty doing the odd, quite a few consumer law matters. Prior to that, I worked at ACCC for 15 years, in a variety of roles, I guess relevantly in enforcement and also in mergers. Now, the outline is quite a lengthy outline. A couple of court cases, quite a bit of enforcement action, some law reform, a number of mergers, a lot of divestitures actually, getting mergers through with some asset sales, a reference to one scam issue, two guidelines, a lot of authorisations, one access matter that's a little bit rare, and inquiries and consultations. Now, the first court case was ACCC and Meg's Flowers, and this was a case in a series of cases ACCC took against flower retailers, including my client Blumex. So there was a few cases, and this case was different. Blumex is related to different issues. This one was alleged conduct by Meg's Flowers in claiming it was a local florist. So as you can see, Meg's Flowers admitted that it breached the Australian consumer law, representing there was a local florist located in each of the town, suburbs, localities referred to in 156 websites and in 7,462 Google advertisements. So it's very extensive conduct. Meg's Flower did not directly maintain any local shop fronts accessible to customers in these locations. Orders placed with Meg's Flowers were fulfilled from any one of 11 Meg's Flowers premises or by subcontractors. So I guess you've got local florists missing out on business because consumers want to buy locally for a variety of reasons, fresh flowers, support local business and so on, and they're actually not getting what they expected. So Meg's Flowers agreed to pay a penalty of $1 million, a fairly large penalty, by consent. Master Wealth Control. This was an appeal by Miss Grubisa and her companies against the judgment of Justice Jackman at first instance, which Justice Jackman's proving to be a pretty solid judge. So I think appealing his decisions is maybe a bit of a waste of time. Particularly this one, he put a lot of effort into this one and really covered all the issues very thoroughly, I thought. But anyway, she appealed, and the full court really made pretty quick work of her appeal and dismissed all aspects of it. So there was appeals by the company and by her in relation to making misleading representations. Sort of a strange case, making misrepresentations about not only the wealth that you could, achieve by following her training programs, but also the operation of various trusts, structures, and also decisions in particular cases. A bit strange. Previously, the federal court found that the DG Institute made false and misleading representations to consumers about two educational programs, Real Estate Rescue and Master Wealth Control, and they were fined quite a lot of money. So in the first instance, they were fined $5 million and ordered to pay redress of 14.7 million. So that's a lot of money. And also, Grubisa was fined $1 million and ordered was disqualified for managing corporation. So appealed the substantive findings of a breach, but also the penalties, and all of them were dismissed. The question is whether she appeals or seeks to appeal to the next level, the High Court, or whether she liquidates the company. I'm probably favouring the latter view. I think she'll liquidate. Now, enforcement, there was a big case in December. It was against Spotless and Ventia. And this was interesting because it was a civil case alleging a cartel between the two companies. So this is a kind of case where the ACCC gets it and has to weigh up whether it's possibly a criminal cartel case or a civil. So for whatever reason, this case didn't quite cross the threshold for a referral to the DPP. So it's a civil case, and it alleges that Spotless, which is a subsidiary of Downer EDI, and Ventia, which is also a big company, had engaged in various conducts, and it's an attempt. It alleges that on 3 occasions between 2019 2022, the companies attempted to make made or attempted to make arrangements or understandings containing provisions which had the purpose, effect, or likely effect of fixing, controlling the prices. So it's actually not an attempt; it's an allegation that they did make an agreement. And interestingly, 4 individuals were also sued. So it's going to be a big case, and it's going to take a while to run. I think both of the respondent companies came out pretty strong and said we didn't do anything wrong. But I guess the main issue here is it's alleging that they sought to price fix in relation to contracts for the Department of Defence. So allegedly, the Commonwealth Government might be the victim of this conduct. And those type of cases, I guess, looking internationally, say in the US, tend to generate much bigger penalties because it seemed to be, the Commonwealth is trying to provide a service and they might be paying too much. I just reiterate, it's obviously allegations at the moment, but that's one to watch. That'll be an interesting case. In the previous month, November, the ACCC said, watch out if you're an NDIS provider, and then a month later, there's a case commenced against an NDIS provider. So this is, I guess, a warning to all NDIS providers. ACCC, once they say they're going to be doing stuff, they generally follow through. So here it's a case against AusNew, which is a registered NDIS provider, and they allege that they engaged in a number of misrepresentations about aged care and disability products. Firstly, they claimed that they made misleading representations about the usual prices at which products are sold. So this is a good old was now pricing, strike-through pricing. As you can see, lower sale price, last chance sales banners, and countdown clocks. So all these things were either allegedly misleading in the sense that the higher price wasn't actually ever charged, or alternatively, the countdown clock didn't really signal that the product would be out of stock at that price once the countdown clock had ticked down. So that's almost a dark pattern type allegation. So that'll be interesting. Also made false and misleading statements, allegedly, that certain products were NDIS approved and about consumer guarantee rights. So specifically, that customers who bought a product who weren't happy with it had to return the product within 7 days of purchase in the original packaging, and store credit would be at AusNews's discretion. So those are all pretty, again, allegations, but if they are proven, they're pretty basic allegations. And I think the NDIS guys don't expect necessarily to be subject to consumer laws or subject to scrutiny by the ACCC, but it's not the way it is. Clearly, the ACCC is going to be very vigilant in this area. So it'll be interesting what happens in the case, but it sounds like a pretty straightforward case, obviously one that I think I'd be seeking to settle pretty fast. Now, Galati, this is a horticulture code case, and the ACCC has been really, really active in this area. We've run a lot of cases. It's a very prescriptive code, and so it's not hard to breach it, actually. And here they allege that Galati breached the code in 2 ways. It traded with at least 4 growers without a horticulture produce agreement in place, so it's pretty fundamental, and providing to growers agreements which did not specify the quality of some produce as required in the code. So 2 breaches, and very simply resolved. Hit them with some infringement notices. So they $62,600 in penalties. In 4 infringement notices, they pay that and move on. But yeah, there's been a very active ACCC with these horticulture code breaches. Mobile Oil, this is a strange case. They got sued in relation to some representations that Mobile Oil Australia was allegedly making in Queensland at 6 mobile branded stations. So it's not extensive or broad conduct, it's really quite localised. And they were putting up signage and posters at these 6 sites saying they were selling mobile synergy fuel, which contains certain additives. And the allegation is that they weren't actually selling that fuel, which seems an odd thing to do if it's true. And then they were also making representations about the benefits of this particular product, and a lot of benefits. Like, this is pretty magical fuel by the sounds of it, that it contained additives which provided benefits including protecting the engines against corrosion, reducing and removing harmful engine deposits, improving economy, reducing emissions, protecting and cleaning the engine, and improving and or ensuring peak engine performance. So that's a lot of representations. There's going to be a bit of expert evidence required here if mobile does fight it, which I don't know if you really would fight it. It's pretty localized. Just, tap the mat and move on. The thing here is there's a couple of representations there which I think are consistent with the ACCC's campaign against greenwashing. So obviously reducing emissions is a big issue for the ACCC because it's one of their priority areas, obviously, green claims. And this is a different ad, so you can see the big posters they had: Synergy Mobile, Synergy Fuels, protect your engine from the first fill. And then they got all these other representations there that were appearing at these 6 sites. So I guess in terms of proving the representation, it's not going to be too hard to prove those. Whether there's any scientific basis for a lot of these claims is going to be the key issue here, whether they just made claims without any basis or whether they actually have some science behind it. Law firm. This is an interesting one. The ACCC issued this report saying that really we needed codes of conduct for all these different digital platforms, and it was be a code of conduct per type of digital platform, so social media, search, and the government was a bit equivocal, I thought, initially. It sort of supported it in principle, and I guess it seemed a bit underwhelming, their response, but subsequently in December they've come out and said, yep, we're going to do it. And I guess what we got here is the consultation commencing from 3rd of December 2024. The ACCC is going to be asking various groups what it thinks about this code of conduct approach. It's very labour intensive, but I think it's a better way of going. Better than just signalling particular companies and going after them, as happened in other jurisdictions. The big thing, unintended consequences, are some companies that you don't associate with the problems are going to get caught up in this. So I think a lot of companies that sell online exclusively have to be aware they get dragged in as a digital platform. Now, mergers, there was the Orican-Duncan merger, and this is one where the ACCC had some concerns, preliminary competition concerns, and I'd never heard of these companies before, but apparently they're the 2 of the largest suppliers of on-street parking solutions in Australia, and there's a proposal for them to get together. And ACCC's preliminary concerns were that it substantially lessened competition in the market for end-to-end on-street parking solutions, as they're basically head-to-head competitors. Also, they're worried that it would enable Orican, as the buyer, to prevent rival providers of standalone parking services from competing effectively, so they could sort of lock them out of the market, give Orican the ability and incentive to prevent or limit the integration of third-party products with their own central parking management system. So related service providers would be allegedly locked out of the market, and then be likely to lead to less competitive tender responses. So when councils seek tenders, there's these 2 guys are in there competing. In the future, there'll be less. So there's quite a few concerns there, and I'm not too sure what the parties could do to get over the line. Maybe some divestitures of some aspect of the business. Then there was this Integral Diagnostics and Capital Health, and this is one where the ACCC decided to let it through after getting some court enforceable undertakings. And this was diagnostic imaging services across various locations in Victoria and Western Australia. And so effectively you get the merger across the line. Integral agreed to divest Capital Health's radiology clinic in the Melton region of Victoria. So quite localised markets. It seems, and the divestiture of this one radiology clinic gets it across the line. And the ACCC says without divestment, the proposed acquisition would have brought together 2 of the biggest suppliers of these general diagnostic imaging services in this particular region, would have resulted in increased prices, reduced bulk billing rates, reduced quality for patients, and they didn't believe that alternative general diagnostic image providers provided much competition. Another one got through with divestiture. So you're seeing a lot of mergers that ACCC express a concern about, and then there's some divestitures. So companies are very, very pragmatic here. It's much simpler to just sell a few assets off. ACCC is very specific where the problems are, and you know what you've got to sell. So here, Viva was going to buy LOC Global from New World Corporation. Again, companies you've probably never heard of, but they basically operate quite well-known retail fuel sites and convenience stores. Solo Oil is the target here. And so to address the ACCC's concerns, the purchaser Viva has agreed to divest basically 14 Solo sites to your competitor, sorry. And these sites are located across South Australia, Victoria, Northern Territory, and Queensland. And these are very localised markets. Now, without the divestiture, ACCC believe the proposed acquisition would increase prices and reduce service offering, particularly in certain areas. So again, this is going to solve the competitive issues that the ACCC identified. Blackstone Group, and this is the one where I've never heard of the companies and I didn't even know how to pronounce the target's name, IROM. But again, this one got through, and this is a sort of a very niche market. Apparently, it's phase 1 clinical trial services. So this is, if you're testing a new drug, the companies which say, well, we can set up a test environment. You can send all these people in. They can try whatever it is, the new drug, and can record all the results of the drug effectiveness. So there are only really a couple of providers of these services. So effectively, the deal got through when Blackstone agreed to sell off CMAX Clinical Research Proprietary Limited. So one of the subsidiaries was considered to be giving the merged entity too much power once it's joined with the IROM group. So there's an agreement to sell that off. Transaction would have resulted in increased price, reduced service quality for phase 1 clinical trial services. Alternative providers of these services were unlikely to constrain the merged group because they're too big and too well established too. I think the probably barriers here might be hard to set it up in a way that's going to be effective. So the divestiture addresses the competition issues as it requires the sale of the CMAX business to an ACCC approved purchaser. Next one was scams, Black Friday sales. And so the ACCC did a sweep. You just see how people are advertising the Black Friday sales. A lot of pressure on retailers to get in on this. And I don't really want to do it, but if you're not doing it, you're going to lose a lot of sales. So I guess you've got companies who are doing it sort of unwillingly, other ones who are doing it in a way to sort of rip off consumers. So the ACCC sweep was a pretty negative findings. They found a number of claims about the size and scope of discounts were misleading. They uncovered a range of concerning practices, site-wide discounts, that they're not in fact site-wide. Potentially misleading was now pricing as well as dubious claims about the value of discounts on offer. So the ACCC wrote to a few retailers, said you've got to fix up your claims, but there's probably going to be more enforcement action about that in the future, so watch this space. And here's some of the ads, save 20 to 50% site-wide, which looks all right. It's a bit vague, like 20% on white, 50% on what? And site-wide, is that everything? 25% off site-wide, including full-priced and markdown styles. What does that mean? Asterisk, where does asterisk refer to? Black Friday up to 60% off RRP. It's very fraught RRP because very often people don't sell anything in RRP. So you're telling people they're going to get a discount off an illusory price that you never see in the market. Black Friday 60% off site-wide. So people are just making these broad representations, and when consumers go in and try to buy the products, they realise a lot of the products are excluded. Guidelines, not much here really, I think. The Immunity and Cooperation Policy for Cartel Conduct, the ACCC issued that many years ago and sends it out periodically for comment, and little changes are made. So they updated the policy to increase transparency and certainty about how the immunity program is administered and to clarify the requirements for applicants. And there's an introduction of a new requirement for immunity applicants to take steps to reduce the risk of future non-compliance with Australian competition law. Now, clearly, it's important for an applicant to sort of say, well, I want an immunity, but I also am going to make sure that I don't engage in breaches in the future, particularly we're talking corporate immunity applicants. Guidelines, sustainability collaborations, that came out. Now, this is a guide that I guess you've seen overseas, a number of overseas regulators have issued in the past, and they a bit late to the party, but really we have the authorisation process here. So I think we're definitely a step ahead of a lot of other jurisdictions. And we've probably been taking these issues, I said we, not we, Australia and the ACCC have been taking these other factors into consideration when faced with mergers and other arrangements which are potentially misleading, looking at the public benefits and clearly looking at environmental benefits. So here the guide is designed to increase businesses' understanding of where competition risks are not likely to arise when you're collaborating about sustainability outcomes. There are some exemptions. Clearly, competition law should not be a barrier for sustainability collaborations, but clearly there's, you got to make sure people aren't using these sustainability collaborations as a cover for some price fixing. That's happened before. The famous case of the US car manufacturers were apparently given some permission in Europe to get together to talk about reducing emissions, and they used it as a cover to engage in the opposite conduct. Sustainability is not limited to environmental issues, include social issues such as anti-slavery and governance initiatives. Exemptions available to small businesses, so small businesses can get class exemptions and also notify collective bargaining arrangements. And there's a quick guide and a 5-step checklist to help businesses. And here we go. There it is. Looks a bit small, but you can see the different steps, preliminary discussions, and then use the guidance. Is it likely to breach the Act? It's not going to breach the Act, then that's pretty straightforward. But if you're going to breach the Act, you have to go further, and then proceed with sustainability collaboration. And a lot in that step 3, but I guess clearly need some legal advice when seeking to go ahead with these deals, depending on how big your companies are. Authorisation, there was a heap of authorisations, and a lot were just formalising early interim decisions which were made by the ACCC. So basically the Bank Code of Conduct was sent out for an update, some changes. It's a pretty wishy-washy code, doesn't do very much in my view, but it's been authorised before and it's being reauthorised. It's an interim approval, but it's better than having nothing, I guess. Not much better than having nothing, but it's marginally better than having nothing. Australian Payment Network Limited. Now, this is another existing authorisation in relation to bulk electronic clearing system regulation. So basically, they want to make a few changes. A lot happening in this space, certain government changes. So effectively, they needed to revoke the earlier one, substitute a new one to give effect to termination suspension provisions under these regulations. Cash in transit, this has been going around for a long time. Basically, ACCC has agreed to ABA, the banks, the retailers, Australia Post, getting together to try and work out a solution here. I don't know what the solution is going to be, but then the BP rewards, that's a reauthorisation. BP rewards is an allegation, it might be sort of like third line forcing. So basically, the ACCC has reauthorised it with a few changes. Effectively, fuel and non-fuel offers at BP sites and participating BP resellers. Also, some reference in there to electronic vehicles, just factoring that in. Australian Payments Network Limited, this has been around for a long time, and clearly with the government's talk about maybe cutting back or removing the cheque system in Australia, there needs to be some changes to this particular authorisation. So this authorisation allows the parties to take certain steps to begin meeting the government's plan and timetable for the winding down of Australia's cheque payment system. My mum's not going to be happy about that. She loves cheques. Anyway, Queensland Rail and Horizon Network Proprietary Limited. This is also granted interim authorisation to collaborate and share information for the purpose of preparing a joint tender for rail profiling services. I don't really know much about that. I don't think you'd be letting these guys get together unless it was pretty innocuous. So I guess it might be something that it needs to be done together to get the best profiling services provided. Soft plastics, another one's been going around a while. This is obviously Red Cycle closed down and that put everyone on the spot. What are we going to do with soft plastics? And so they grant authorisation with conditions to the major supermarkets to continue their collaboration to recycle stockpile soft plastics and continue a pilot in-store collection program until 31 July 2026. Then hopefully there's a long-term solution. Catholic Health Australia, this was an authorisation to basically boycott private hospital, large private health insurers. I didn't see any public benefit here, and the ACCC has decided to deny that authorisation. So these Catholic Health hospital members aren't going to be allowed to boycott the large private health insurers. Pilbara isocolit, this has been around in the last few months as well. And this is the Northwestern Connected System. So it's a big system and it needs different competitors to work together to make it all work. As you can see, it's relating to safety, security and reliability. So not competition-related issues such as pricing or marketing. Then there's this Tabcorp Vic and Racing and Wagering Western Australia. So this is a reauthorisation. Basically, Tabcorp allows RWWA to participate in the Super Tab Totalisator pool. And there was an authorisation previously granted to another entity in the Tabcorp Group and reauthorised 2016. So it's just continuing the arrangement. Obviously, some benefits here by allowing RWWA to be part of this broader group, obviously reduce costs and things like that. The Copping Refuse Disposal Site Joint Authority, this is one the ACCC said they didn't think was much public benefit arising from it, and sure enough, they've knocked it back. I didn't see any public benefit. I know why you need an authorisation to design, build and operate a contained organics waste facility. I don't quite understand that one. But anyway, the ACCC said no public benefit, so knocked it back. Then there was an access decision, which don't come out that often, but effectively the Australian Rail Track Corporation has to propose access undertakings to the ACCC and get them to be approved. So here, the ACCC issued a final decision to accept the new access undertaking for interstate rail network to provide an updated regulatory framework and an enhanced platform for engaging between ARTC and its customers. So it goes all the way to 2029. The aim is to substantially improve dialogue between ARTC and customers, better consultation, added performance of financial reporting, things like that. Undertaking will regulate the rail monopoly through a move from 8 reference services to a current single service. That makes sense. That was very confusing previously. Practical approach to current pricing that is tied to CPI and give certainty. Customers need that. And improve undertaking in terms of disclosure and the use of commercial arbitration when there's a dispute, that they can go along and seek to get access and then ends up potentially in court. Collaboration between ARTC and its customers to enhance the usage and efficiency of rail. So this is proved and not have to worry about it for a few years. Inquiries consultation. So there was the 9th Digital Platform Service Inquiry. They went back to the general search issue and they concluded, the ACCC, that Google's dominance in general search services in Australia has continued despite changes in the market. That wasn't surprising. Google's maintained its position as a dominant search engine in Australia, 94%. We just love Google Chrome. Its nearest rival, Bing, 4.7, is not growing. And then Google continues to be the default search engine on the majority of browsers due to commercial pre-installation default arrangements. So you might recall there was some undertakings by the big 3 telcos not to get money out of companies to be the default. It's still going to be default. They're just not going to get money for it anymore. They're just a preferred browser. It's going to be preloaded on most phones and other devices. So this is all going to be interesting in the context of the Code of Conduct, which the government's consulting on at the moment. How is Code of Conduct going to work here? What issues is it going to deal with, like self-preferencing and other issues like that? Broadband, Measuring Broadband Australia program expanded the things it looks at to include satellite services. So Starlink and NBN Sky Muster. And Starlink was really miles ahead of Sky Muster. It outperformed Sky Muster in terms of delivering higher data transmission speeds and lower latency. There's lots of stats in this particular report. I don't think I want to record them all here, but just for example, maximum speed for NBN Sky Muster was 111 Mbps for downloads and 22 Mbps for uploads. And then you compare that to Starlink, 470 for downloads and 74 for uploads. So it's chalk and cheese, really. I don't know why NBN doesn't pick up its act there. It's just miles behind Starlink. Then the NBN, there was the report by NBN on its expenditure and price report. And this comes from the special access undertaking, which you may recall took ages to get through the ACCC, kept getting rejected and had to be changed and finally got through. And now they're reporting on how they're complying with that SAU. Now, the problem with this is that, it's very confidential, a lot of pricing and issues. So the ACCC can't really talk too much about what's in it. So really what it does, it says a pretty broad sort of report on it. It says, the report by NBN sets out capital expenditure, operating expenditures, a comparison against forecast expenditure. So are they on track? Where the price is charged for NBN offers and other charges for core regulated service exceeded at any time the maximum allowed price of tariff list. So obviously not. And then the ACCC is not putting it out for comment like with other reports, but rather it's sort of assuring everybody that we're keeping an eye on this, and we're making sure that NBN follows the undertakings it provided. So the ACCC's got all the confidential information and is assuring us all that NBN is not breaking the rules. Freight, ACCC container stevedore monitoring report. This is bad reading. I remember I did a waterfront case many years ago, the ACCC, and it's quite obvious that the whole waterfront is just market failure after market failure. A lot of duopolies, monopolies. It's just major problems. So here, this is all really reflecting all that. Global and domestic disruptions continue to destabilise the container freight supply chain, leading to congestion, delays and higher costs, which results in some importers having to pay 4 to 11 times as much for ocean freight as a year earlier. So that's not good. We're paying too much for freight to Australia, pushing up prices. Limited competition on landside charges charged by the stevedores. So, they can't charge high price on certain things, so they push up the charge on landside charges. And also now the empty container parks. That's always a problem because, that's not regulated and you just charge high prices. Stevedores and empty container parks appear to have little incentive to pursue increase in market share by discounting. Why would you? You're a duopoly or an oligopoly, you're not going to compete. Stevedores have materially increased their overall prices by significantly raising landside charges over the past 7 years, and that's on the landside charges, and now they're pushing up empty container parks. And here you've got it. So this is a diagram, notification fee. So basically you've got to pay a fee if you're notifying about empty containers, and as you can see there, they've just been going up and up and up over the years. It's not like rocket science. This is not actually making anything. It's moving big boxes, empty boxes around the place. So, it's big margins really for doing very little. And here you can see the two major offenders, Sydney and Brisbane, very high prices. But everybody's been going up. Like all the stevedores have seen, this is a great way to make easy money. Electricity. This is really just alerting consumers, and probably included in this. We're not really looking after our best interests. You can really do much better by switching your electricity provider, but so many of us aren't doing it, myself included. So despite the price of electricity falling between that period, many households remained on higher offers than they could be on. So there's this government safety net, and we're actually above the government safety net. So we better just going off any deals and going on to the standard government safety net price. 80% of Australian households in the National Electricity Network could move to cheaper electricity plan if they shopped around. I really got to put that on my list to do because I'm paying too much, obviously, as most people are. And there you've got, the way that the offers have changed. So the offers basically in the past were much higher, well, not much higher, but they were higher, and then they've all dropped across all these different areas. So NEM, New South Wales, South Australia. So you've got all South East Queensland, Victoria. So you could save by getting off your old offer and going to a new offer. And this is the number of residential consumers who are really not on the best offer. And it's like, it's a huge amount. 20% are on the best offer, customers on best offer, and 80%, and I'm in that, what colour is that? Gold, on that gold column there. We're not getting the best offer, so you really make that a priority. That's what ACCC is trying to do, encourage people to shop around. Now, commentary, the Grubisa case is interesting. I think that's probably the end of it. I have a feeling Grubisa, she can't pay, $5 million. She doesn't want to pay $4.7 million in redress. She doesn't want to pay $1 million fine. I think she'll probably liquidate that company because she doesn't have the money. Can't see an appeal to the High Court, and I hope she doesn't come back in some other guise in the future. Disqualification, I thought maybe a few more years would have been good, a disqualifier. Spotless Venti is going to be really interesting. It's an important big case. It looks bad. I guess it comes down to the evidence. There seems to be a maid and an attempt. So I'm just curious about that. Usually it's one or the other. So maybe they made a successful agreement, allegedly, and attempted to make others. I don't know. Sustainability collaboration guidelines. I guess it's good they're out. I think companies have been basically putting these arguments to the ACCC for years on authorisation process, but this obviously provides a bit more guidance to business, particularly non-environmental like anti-slavery and other issues. Merger of divestitures. It seems like you get merger through if you're sensible and you want to sell off a few assets. ACCC is very good in identifying what you need to get rid of to get it over the line, and I think a lot of mergers can make it. Digital platform code of conduct, that's going to be a big area of debate the next few months. The government's going to consult, and I just don't know the timing's great. I don't think the government can actually implement anything before any election, but it can make some strong noises and maybe get some maybe a draft out there or something, but I can't see anything passing. And I guess the main thing for a lot of businesses, if you're doing a lot of online sales, just make sure you're aware of what's going on. Don't get caught up with it. Unintended consequences here are a big issue. Google and stevedores, both problematic. Google, I guess, just does things a lot better than other people, and it's acquired this very strong position in the market. Clearly, where it seeks to take advantage of its big market position to maybe self-preference or discriminate in some way, that needs to be controlled. Not really evidence it's happening in Australia, clearly happened overseas, but that's all tied up with the digital platform code of conduct. Stevedores is just such a big problem. Like, it's just, these guys, the government comes in and pays all these redundancies for maritime union workers. The stevedores rarely pay the redundancies. It all comes from the government, proposing levies, consumers pay, and then the stevedores, this first chance they get, they put their prices up. So I don't know what the solution there is. There's just no incentive to compete. And it's just a very, very bad situation for Australia, given that we're a big importer, big exporter country. So that's all I had. A lot in December. I think I've taken me about 40 minutes roughly. So I think that's pretty quick. And I'll be trying to get January done in the next week or so, and then I'll be totally caught up. But yeah, December was a big month. If you have any questions about any of this, feel free to give me a call or send me an email.